Thank you, everybody, for joining us back here again. Got some notes. Gonna call the Supreme Court.
You have reached the Tennessee Appellate Courts. Our office hours are 8 a.m. to 4:30 p.m. Monday through Friday. If you know your party extension number, you may dial it now. For Supreme Court and Court of Appeals, press 1. Court of Criminal. Please hold on while I try that extension. Good afternoon, Appellate Courts. Can I help you?
Yes, my name is Jonathan Cross, and I was just wondering when the Supreme Court of Tennessee was going to witness Phillip Kemp's writ of Restore Freedom.
You have case number?
If you give me just a second, I can pull that up for you. It is E2021-00646-SC-UNK-CO.
I'm sorry, what was your name?
My name is Jonathan Cross.
And who are you calling on behalf of?
The law.
Which party, sir? Are you there, sir?
Yes, ma'am.
Okay, I was just asking which party you were calling on behalf of.
Well, I'm calling on behalf of the people in this country who wish to see law upheld.
Okay, well, several people have called about this case already last week and today, and the order has already been filed and uploaded to the website that you'll have immediate access to it if you'd like to read it there, but that petition was denied.
Okay, and see, here's where the problem comes in, is because, you know, we were told all week last week that, and the week before that, this was going to be handled by due course of law, and in due course of law, they're supposed to witness the writ. You know, it's not a petition for restoring freedom, and
Sir, like we've explained to everybody else that's called here for this particular case, the filing that was sent here, we only hear appellate cases. And what they're asking for doesn't demonstrate appellate review. So your argument really needs to be with Chancery Court for Washington County. The Supreme Court here did not have the right or the jurisdiction to review this because it wasn't appellate procedures.
okay, and I'm going to talk about that because I comprehend y'all's position, but the problem with the order that I see is that there's no signature giving it authority. There's no judicial signature giving it authority. And I'm sure you're going to inform me that this per curiam or something, it's written in Latin, so I don't know what that word is, but I'm sure you're going... Yeah, it means all members of the court. But see, here's Article 6, Section 12 of the Constitution for...
Sir, I don't mean to cut you off, but unfortunately all the questions that you're going to have for me are not questions that I can answer. I'm simply a clerk in the appellate court clerk's office. We don't have anything to do with the orders. All I can tell you is that the Supreme Court has put down their order. You do have access to view it on the website if you choose to, and I can give you that web address and you can see all the filings there if you'd like. That way you can always keep up with it. As soon as we file something, it's automatically posted to the website.
Okay.
Would you like that address?
No, thank you.
Okay. Well, if there's nothing further I can do for you, I appreciate your call and have a great day.
Really? You're going to hang up on me?
No, sir, there's just nothing I can do for you with your questions. I apologize, but I'm very limited in what I can provide to you.
I don't really have any questions. Okay? I'm sitting here saying that in Article 6, Section 12 of the Tennessee Constitution, it says all writs and other process shall be signed by the respective clerks. There's not even a clerk signature or initial on this document. Okay, in this document.
I understand what you're saying, and just like I don't know if we've spoke to you before, but just like we've told everybody else that has called with the same statement, if you have any concerns with the court, you're more than welcome to do it in writing. Unfortunately, we don't take anything over the phone, and as I've told you numerous times, it didn't proceed to appellate procedures, therefore our court cannot rule on it. So if there's any argument that you have with something the court has done, again, you're more than welcome to do it in writing.
Okay, and the problem that we, the public, are having with what you're saying right now is that we are unable to access a court of law, just like Phillip Kemp could not file a suit of barratry when he was supposedly in an open court of law. So, if we had access to a court of law, I would have no problem doing those things.
And so there's nothing stopping you from having access. Like I just told you, you're more than welcome to put something in writing and submit to the court. You can do that at any given time.
Yeah, but the problem is that the courts aren't proceeding
on our end. I understand that
under.
You're frustrated on your end, but there's nothing I can do to help you right now.
I
apologize for your frustration, but you're asking things of me that I can't give you answers. I can't give you legal advice, and there's really nothing further that I can do to direct you. I've told you everything that you have as an option.
I'm not asking questions. I'm not asking for legal advice.
And if you're just venting, I apologize, but there are other people that I do need to assist that have questions that I need to help answer. So this phone call is pretty much moved at this point.
So basically, because the Supreme Court is using a Tennessee Code annotated 16-3-201. I have no clue what that means. But what I do understand is that the Supreme Court was created by the Constitution of Tennessee, along with the legislative branch and the executive branch. And if the legislatures can confine the jurisdiction of the Supreme Court, then they're not exactly distinct and separate powers if the legislature can usurp the powers of the court, the judiciary.
And again, do you have a question for me, sir?
I don't necessarily have a question. I'm asking.
This phone call because there's nothing that you've asked me that I can assist you with. I apologize for that, but I do hope you have a good day. Thank you.
Okay. Obviously, the Supreme Court doesn't care. They have not answered the writ. And they haven't answered the writ because they haven't answered in law. And obviously, they don't care about answering in law. They just sent a piece of paper that they just printed up. And they expect you to believe that that's good law. If you believe this piece of paper, okay, then what they're telling you is that there is no separation of powers. That the legislature can just take away the judiciary's right to uphold your rights. And that should be incredibly scary. Now, I'm going to tell you, since they don't wish to listen, and I'm sure somebody's going to send this to the Supreme Court, and Don Ash has already said that he's listening to everything Kemp and I are talking about. I'm sure he's seen some of the videos. So, what they're doing is they're speaking to you in a language that you don't understand. Okay? What they accuse sovereign citizens of is speaking in some type of code that nobody understands and being above the law and not respecting the law and not respecting due process. This is exactly what they're doing. They're speaking in a code. They're speaking in the Tennessee Code annotated. Okay? I don't know what that means. They have other things in Latin. I don't know what those things mean. And they can't answer the writ in law. They can't answer it in law because there is no law. Look, Article 1, Section 15 of the Constitution, and when I went over this a week ago or whatever, I said, we'll see about this, but the privilege of the writ of habeas corpus shall not be suspended. Now, we don't really know what the word privilege means anymore, but the etymology of privilege is private law. Your right to private law and to have your own court and to issue a writ to the highest courts of Tennessee, which is the Supreme Court. And if there's any law to be found, that's where it should have been. Your court is higher than the highest court of the state because you're man, you're woman, you were created in God's image. The state is just something that people made up. Okay? So your privilege, your private's law to issue a writ of habeas corpus shall not be suspended. I don't know if it's suspended. I think they just took it away. Okay? After the Civil War, they started changing it to petition for writ of habeas corpus. And how did they get away with this? And this is why the wording is still writ of habeas corpus, is because if they would have changed it to petition of habeas corpus, everybody would have gotten real upset and revolted because they would have known that the law was being taken away from them. But the way that they actually sold this to the people is they said, hey, we're not taking the law away from you good white folks. We're just trying to keep the slaves as slaves. So we're not going to allow them to access the law. And that's why we're going to make them petition. And everybody was okay with that because, I guess they were racist. Anyways, that's how they sold it. But what those people didn't understand is they were really selling the rights of law for their children and their grandchildren. And this is where we're at right now. Now, there's no signature on this. So for all the police officers out there who say, hey, all I know is I got a court document with the judge's signature on it, what do you think it means when they won't sign it? What do you think it means when nobody will put authority to it? Because they know it makes them liable in law. Think about that. Think about what they did to Phillip Kemp. They tried him, giving him no due process or a right to a jury. They found him guilty because they agreed with themselves. They threw him in jail basically because he wouldn't be a voluntary slave. And then, because of what we did, what we all did out here, they changed putting it in the appellate court to putting it in the Supreme Court because that's what due course of law is. And that happened because of our phone calls. And then they denied it because, they said he was getting out on Friday. They wrote an order. Now, I didn't think that order from Don Ash was exactly lawful, but they were doing the right thing. And so I'm not going to argue it too much as long as they're doing the right thing. And the reason I'm saying it's not lawful is because if you witnessed me talk about True Law Explained, Don Ash was an accessory before the fact and after the fact to the bargery that Suzanne Cook committed. Not only was he an accessory before and after the fact, but he aided and abetted Suzanne Cook in committing that bargery. He denied Kemp access to a court of law, denied Kemp access to freedom of speech and to speak out against his government, denied Kemp his right to freely worship and raise his children the way the Creator has instructed him to do so. Don Ash deprives Kemp of life and liberty without judgment of a jury, and the Supreme Court enjoins him on this action. I don't know how much more clear I can make it for you. And we were all excited he was going to get out, and then an hour before he's supposed to get out, Don Ash pulls him into a hearing and rejudges him. Now, in law, that would be double jeopardy. Being put of having your life, liberty restricted twice. But in their administrative procedure, I guess it's okay. What do you think? What do you think? And that's Article 1, Section 10 of their Constitution. Article 1, Section 10. And now the people at the jail are refusing to file Kemp's paperwork. So I've been told. And I believe it because I've been told by Shaman, and I talked to Kemp last night, and he was worried about that. He was worried about that very same thing. So, Supreme Court, we the people wish you answer the writ. And if you're going to say that the writ is no good, then we wish for findings of facts and conclusions of law. And we're going to keep calling and asking, when are you going to uphold this writ? Or when are you going to give us findings of facts and conclusions of law? Because your argument's so weak that you didn't have any conclusion except for the legislature's allowing you to get away with this. That's it. That's your whole reason for dismissing it. That's pretty lame. Now, Chief Jeffrey S. Bivens, I hope I got your last name correct, but Chief Justice of Tennessee, see, I wasn't even able to get far enough because your clerk just hung up on me. Just hung up on me. Won't listen to me. Won't listen to law. And I don't necessarily blame the clerk because I know that you're ultimately the man in charge. So, Chief Jeffrey, from Chief Cross, Chief Jeffrey, your tribal members are harming and injuring and causing great loss to people in our tribe. So, Chief to Chief, I wish to know what you're going to do about this in law. And when we're going to see you administer some sort of justice for what Don Ash did. Because anybody who doesn't understand the fundamental principles that man has the right to access a court of law all the time and that can't be denied, and that man has a right to freedom of speech and to speak out against the government and the courts when they don't agree, and the right to worship and praise their creator in their own way and raise their children the way they're instructed to by their own conscience given to them by that very same creator. Anybody who doesn't understand these very simple, very fundamental, very principal rights of our culture shouldn't be sitting up on a bench. And American people, if you're watching this, come join the conspiracy or pick a number and get in line and wait for this to happen to you. Because as you can see, no authority in the state is going to uphold law or due process. Pretty clear. And for all of the police officers and the sheriff's department, we stand with you and stand behind you 100%. If you stand for law and rights and justice, and you understand that people shouldn't be locked up for taking children camping on their parenting time. If you stand for that, we stand with you. And for everybody watching this, keep calling the Supreme Court and asking when they're actually going to follow due course of law. Like, when will that happen? Because if they just hang up on you, they're telling you that they're not going to. If they're telling you, well, we put up a piece of paper and you can go look at it right now, what they're effectively saying is that we don't care about your due course of law. We don't even care about our own due course of administration, which is why no respective clerk signed that order. We don't care if you guys understand what we're saying or not saying. We don't care if we speak in a different language to take your property. Keep calling them up and asking them when they're going to care. I'm telling you right now, if we would have had the people to make sure that they couldn't have done this on Friday, if we would have had the people massed outside the courthouse, I bet they would have a very different tune right now. And Kemp goes back in on the 30th. He goes back into court. 9 a.m., Washington County, Tennessee. I hope that we have more people. I hope we have enough people to uphold law. And if we don't have enough people to uphold law, we're not going to have any. This is, in my opinion, this is kind of the last chance to settle this peacefully. I think one of the most disappointing things for me with my whole experience last week is, Kemp went and fought in a war for our rights and protecting our rights, and he got back home side, and he keeps fighting for our rights. And I was hoping that some people from the military who know what war is like and don't wish to see it on their doorstep over here in the home front, I didn't see anybody show up. I didn't see anybody show up. Anyways, the ball's in your court. Right now, whether we have law and due process, or whether the people are just going to allow the government to administrate everything away from them. This is a court going on right now, and it's the court of public opinion. It's the court of you. You're the jury. All I wish to do is conspire with other good people on this planet to create a better world for my little man in training and your little people in training, so that they have a better world than the world we grew up in. And clerks and officers on the other side, I wish to do this for you and your family as well. But I'm going to ask for a little bit of aid and assistance. I pray for a little bit of aid and assistance, because you can see what the other side's doing. You can see how they don't care about rights, law, justice. They don't care about that stuff. They just care about the perception, the public perception of their administration of justice. And that should be fading, if not all the way disappeared. Anyways, please join us on the 30th peacefully. We just wish to conspire with other good people of this planet to leave a better world for future generations than the world we all grew up in. One for love and peace. Okay, I kind of forgot to talk about this. If anybody calls up to the sheriff's office, tell them that we support them, and we hope that they support us. We hope that they understand it's wrong to lock somebody up for going camping with their children, and it's even more wrong to tell them that they're going to get out to see their children on Father's Day and to be with their firstborn son on his birthday, and then to just straight take that away from them. But please don't harass the sheriff's department anymore. That's just my word. And keep calling, asking the courthouse when they're going to open up a court of law, when they're going to allow Phillip to access a court of law. Keep calling the Supreme Court, telling them you don't believe their administrative process, and it's your wish that they go by due course of law. And if they're going to reject the writ of restoring freedom against somebody who, even the judicial officer who locked him up said that he didn't hurt anybody but himself, then they should answer it in law with the findings of facts and the conclusions of law, written in plain, simple English, so all of us common people, all of us simple folks, can understand it. Thank you. Peace.